by a certain date. If they don't, it's very difficult these days to go to get an order to kick a tenant out. It's always hard in any time, but COVID's made it even harder to go and get a hearing and get an order to get a tenant out. So you got to at least start with the fact that the tenant has agreed to leave by a certain date. And you want to make sure that it's the seller has the obligation to make sure that, that they kick them out or get them out or do take whatever action you need to get them out.
Hey, David.
Yep.
Would you like to do a seminar on this topic? We get questions about this all the time, don't we?
Yeah. Yeah, so maybe we should put something together on that.
Okay, let me know when you're ready to do that.
Yeah.
So if let's say there's nothing in writing and I put something in the clause saying seller agrees to provide N11 from landlord and tenant board signed by landlord and tenant within the 5 days of the date of acceptance, they should have a vacancy date prior to the closing date. Like, I don't know, would that suffice?
Yeah, that would. But you might also, if you're on the buyer side, you may also want to have something saying that, make it clear that it's the seller's responsibility to take whatever action that, at its expense to make sure that there's vacant possession on closing.
Okay.
And does the buyer want to have the right to extend the deal in case they can't get, the tenant out?
Mm-hmm. Yeah. Yeah, because it's very close because they want 60 days closing or whatever, but then tenant is going to leave in 60 days and it'd be like, okay, then that's like, there's no room to maneuver on the last day, right?
Yeah.
And also, yeah, basically that's the whole thing.
Right, because if the buyer doesn't have a right to extend and the tenant doesn't leave and they can't give vacant possession, then, the landlord, the seller basically can't complete the transaction and the transaction could be terminated because of that, because they can't get the tenant out unless it's, so from a buyer's point, if the buyer's prepared to extend and have the right to extend, or does the buyer want the deal to terminate and they'll move on to another property?
Mm-hmm.
So
yeah, but then waiting 60 days is just waste of time for everybody.
It could be, because you may not be able to get them out in the 30 or 60 days, even if you're extending.
Yeah, I mean, the listing agent is saying that there's an agreement that they will leave. Mm-hmm. So it's like a kind of trust base.
Yeah. Well, you want to see it.
Yeah, that's right.
You want to take their word for it.
Yeah.
Dawn, did the share screen come up?
Yeah, you're good.
Okay. You let me know when you want me to start.
Okay. Can I call you after this, David?
Sure.
Okay. Thanks.
Okay.
Ready whenever you are, David.
Okay,
well, a little intro today. Hey, everybody. So once again, this is our legal series. This is our last scheduled class. These have been such a hit, though, so I'm sure we'll be inviting David back to do lots more of this. We were just chatting before we're getting started today about the fact that every week we have questions about landlord-tenant rights and how to get a tenant out if you're going to sell the house, and who's responsible for what. So David is going to very graciously go and put together a presentation on that topic for us, and I'll let you know as soon as we'll be running that. Today we're talking about defect disclosure, which is another new topic for us, basically because we kind of went off track with it in another seminar a few weeks ago. So I want to know what we have to do about ghosts. And now I'll hand it over to David.
Yeah, thanks, Dawn. That's a great intro. And that's right. This topic sort of came out of a discussion we had on, a number of weeks ago on completely other things. But this is something we get asked about all the time from agents. And so anyway, I think you're going to enjoy this topic because it's issues that come up all the time. And it's not just talking about the ghosts and the goblins. We're going to get into that because we're going to talk about the stigmatized properties. But what about other things that go wrong in a home? What, leaks and, and other damages, and what are the duties to disclose that? So I think this is something that you're going to come across as an agent all the time on any resale transaction for sure. So I think it's important to try and get an understanding. So we went through this, we look at it from 3 different points of view, which I'll get into. So let me just get through our intro slides here so we can get to the meat and potatoes, because it's one of my favorite topics actually to talk about these things, because it's interesting. There's interesting stories that come out of these things as much as anything. But it's what is the duty to disclose? And I want to talk about it from 3 different points of view, so you'll see it from different perspectives. One is a seller. What's your seller client's duty to disclose? What is their obligation? What is your obligation as a real estate agent to disclose? And then what is my obligation as a seller's lawyer to disclose? Because they're all different. They all come from a different point of view, the way the law treats it and the regulations treat it. So we're going to look at, when we talk about each of these things, like different types of defects and stigmas and things, we're going to look at it from these 3 different points of view, so we can all have an understanding of where you come from. It's not only you have to understand what your role is, but you have to understand what your seller can and cannot do, or should not say or disclose, and what their lawyer has to do as well. So I think it's important to look at it from all 3 points of view. And what might be surprising to some of you is the basic law in Ontario, and there is no duty to disclose that's just stated in Ontario law. There's no duty to disclose by a seller or by a seller's agent or by a seller's solicitor. There isn't a law in Ontario that says you have a duty to disclose X, Y, and Z, and this is what you have to disclose and what you don't have to disclose. So we have to figure it out because there's no particular law. So let's go through general principles that will help us to understand what's going on here. So let's start from a seller's point of view. The common law does not require a seller to disclose a patent defect, even if it's known to seller. And I'm going to go through the difference between a patent or patent defect and a latent defect in a couple minutes. We'll break it down. The common law in Ontario requires a seller to disclose material latent defects if they are known to the seller. So those are the general principles from a seller's point of view. A patent defect, do not have to disclose, even if you know about it. A latent defect, you do have to disclose if you know about it, if it's a material latent defect. And sometimes the word material makes a difference as well. Now, from your point of view, okay, your seller client may not have to disclose, or they might have to disclose, but from a seller's agent's point of view, your responsibility as an agent is to comply with the Real Estate and Business Brokers Act, which has now been replaced by the Trust and Real Estate Services Act, TRESA. And basically that's what regulates you as a real estate agent, and then they give the responsibility over to RECO, to the Real Estate Council of Ontario, to enforce the rules for you real estate agents and brokers. So you have to follow RECO. You have to follow RECO regulations and guidelines and codes of ethic. So that's where it comes from, your responsibility as an agent. It doesn't come from any particular law or case law. It becomes from your RECO regulatory rules and guidelines. So when it comes to disclosure under RECO, if a defect is known to you as an agent, you have to avoid misrepresentation or error when promoting a property, and you can't be untruthful. Okay, those are your guidelines. So you have to keep that in mind when there is something that you're contemplating whether to disclose or not. You can't avoid misrepresentation or an error, and you can't be untruthful. So those are the guiding principles. So when you're asked a direct question about a defect or something, the seller's agent has 2 options. One is you answer truthfully. And you have to, in order to do that, you have to get your client's consent. They have to know that this is going on, okay? Because you're forbidden to answer falsely. So you have to answer truthfully. Your client has to know about it. Okay. The other option you have is to decline to answer. And you could suggest that the buyer and the buyer's agent do their own independent research. Now, obviously, I think it's obvious, if you decline to answer, that's going to raise a red flag to a buyer and a buyer's agent. But sometimes that's the route you have to take. You say, you know, I can't answer that question, but you know what, the seller's going to agree to an inspection clause, or you can do your own investigation or check it out before you put an offer in, because I can't answer your question. So whether you're going to choose to answer truthfully or decline is really not your option either as an agent. The option is up to your seller or client to tell you which way they want you to proceed. So obviously you have to explain the ramifications to the seller and then get instructions from the seller which way they want you to deal with this. Now, if you don't agree with the seller's ultimate strategy, then what do? So you have another two options: either comply with the seller's wishes and do it in accordance with your instructions, or you have to decline to work with that seller. So those are the basic guiding principles that you have to keep in mind, okay? Everything flows back to your RICO regulations and your duty to disclose. That's where it comes from. So just keep these general principles in mind when we look at the different types of situations that you get into when you're trying to figure out whether to disclose, okay? And by the way, the disclosure statements, such as the seller property information statement, are voluntary in Ontario. They're not required in every transaction, so you don't have to have that. But if you do, you got to make sure you complete those properly in accordance with the principles that we just went through. So now you hopefully understand what you've got to contemplate as a seller's agent. From my point of view, from a seller's solicitor, it's really much simpler. We, as lawyers, we have a duty of confidentiality and solicitor-client privilege with our client, the seller, that just prohibits a lawyer from disclosing unless we have specific instructions from the seller to disclose it. So I can know, you know, about the whole history of the property. I can know where the dead bodies are buried in the walls, but I have no duty to disclose that to anybody. As a matter of fact, I'm prohibited from disclosing that unless I have instructions from the seller, because the seller's the lawyer's client, and we have a duty of solicitor and client privilege that trumps anything else that we have to do on a transaction. So that's where my duty lies. So it's pretty straightforward from a lawyer's point of view. So let's just break it down a little bit more and discuss the difference between types of defects, the patent or patent defect and latent defect. So first of all, patent defects. So what are they? These are things that are visually observable. Okay, that anybody that walks into a property should be able to see it during a regular walkthrough. You don't have to be a home inspector to see that there's damages. It's anybody on a reasonable inspection of the property would see that there's certain defects. It's obvious things that could be discovered by any prudent buyer without disrupting the property. Without, for example, you're not breaking drywall to see if there's mold behind the drywall, but you might see it, evidence that there's a problem just to the naked eye. Okay, and again, the test is, you know, it's on a layman's term. It's not a home inspector's term. It's anybody that you're bringing into a property should be able to see these things. So examples are clearly visible cracks in foundation walls, a hole in the wall, a missing safety railing, visible stains that, you know, that indicates that there was a leak or a history of leak. If there's visible mold growth that you can actually see. And again, this is without breaking any walls down or poking into any walls. So what's the duty to disclose a patent defect? Again, we'll look at it from three different points of view. From a seller's point of view, there's no obligation or requirement to disclose that. And the reason is the buyer can see it for themselves. The buyer just walking around, the buyer's agent should be able to discover what these things are. And they can question it at that point in time. And they might accept the property the way it is. They might require those things to be fixed. They might pass on it. That's up to them, but they can see that it's there. So they know exactly what they're getting themselves into. They know exactly what they're putting an offer in because it's obvious to them. So there's no duty for the seller to disclose it. Now, a seller cannot take steps to hide those type of defects. If they attempt to conceal that, then they can be open to an action, because that's a fraudulent action if you're just trying to hide that, and it could give right to a buyer to make a claim against the seller for damages. Okay, so if there was something that would be obvious on a walkthrough, and the seller takes action to hide it, by just painting over a stain when they know the leak hasn't been fixed. Okay. Now, if there was a leak, people have the right to fix their property. They can fix a leak, they can re-drywall it, they can repaint it, retape it, do whatever they do. But now it's fixed, so they don't have to disclose that at one point in time there was this leak. But if there was an ongoing leak and there's a stain that would be showing that, and they just paint over that and don't disclose that, now they're getting into this area where they might be taking steps to deliberately hide a defect, because they know that next time it rains, the water's coming through there again. But they're trying to sell the property and pass it by a buyer without the buyer being aware of it. So that you're preventing the buyer from seeing what they should be able to discover on their own. Now, from a seller's agent's point of view, again, for a patent defect, no requirement or obligation to disclose this. And the reason, again, is the buyer has the ability to discover this on their own. And again, obviously, as an agent, you should not be taking any steps to deliberately hide a patent defect, and you should not be advising your client to do it as well. And again, from my point of view as a lawyer, we obviously have no obligation to disclose any patent defect, except if we have specific instructions from a seller, because we always have to follow a seller's instructions, and the seller's not likely to provide those instructions to tell people about their patent defects. And again, my advice to a client would always be, do not hide it. Do not take steps to hide it. You can fix things, make sure it's fixed properly, but you can't hide something. There's a big difference. Now, latent defects are a little bit different. These are things that are not easily seen or apparent or discovered by the buyer. This would generally require a home inspection, someone qualified to look for these type of defects. It's not something that just a layman can walk through. Now, I've dealt with a lot of real estate agents over the years, and I know some of you agents are fabulous at, you're practically home inspectors because you've got the experience, you know what to look for, and you're really good at it. So some of you might be in that classification as well. Some are, may not be as comfortable. But generally, for a latent defect, it's not going to be visible unless there's some invasive type of inspection that goes on. So, and generally, when you're selling a property, you don't want to give every potential buyer the right to do invasive inspection. You're not giving the right to open up the wall, etc. But home inspectors generally know where to look to get a general feel for it. And what they're looking for often is not just, is there a defect there, but does it go to the level of making the property unfit to live in? Like, is there mold in the walls, and is there evidence of that mold somewhere? Something to that effect. Because if it is unfit for a buyer's purpose, then the question is, should that purpose be known to the seller or the seller's agent? Okay, was it known? Is that defect known? Now, examples of latent defects, here's a list of some of the ones you would come across, and some of them are pretty obvious, like flood damage, a crack in the foundations, there's a structural defect, there could be hidden water damage, damage to utility systems, there could be fire damage. And again, even when you're looking at these, things happen in homes. People live in homes. People do have floods. People do have fires in their house. They're allowed to fix it. And if they do fix it and they take proper steps to fix it, it's no longer a latent defect. It's something that was fixed. So we're talking about things that happen. There's damage, but it hasn't been fixed. It hasn't been fully repaired. And it's not readily seeable to just the naked eye. It needs some further investigation, okay? Toxic mold, which can't be seen, foundation leaks, a cellar finished basement, and there's covering large cracks in the basement that could affect the structure, finished basements or additions or a garage that are built without permits. So they may not have been built in compliance with building code, things like that. Another example, a seller knows when it rains, there's water that enters their house. Sometimes it's not from from a leak somewhere. It might be coming up a drain in the basement, but it happens all the time. And when there's a big rainfall, or maybe it's only major rainfalls, marijuana grow up, which hasn't been remediated properly. So these are examples of things that could be latent defects. Okay, but just keep in mind the general principle that a true latent defect is one that was not known either to the seller or the buyer at the time of the sale. So these are things that come up afterwards, okay, for it to be in the latent defect category. So what's the duty to disclose a latent defect? So again, we'll look at it from 3 points of view. From a seller, there's an obligation to disclose to potential buyer, especially if the property is dangerous or likely to be unfit for habitation. Okay, but obviously you can only disclose it if the seller is actually aware of it. So the seller has to have real knowledge that there's this issue. So a lot of times people are living in a home for a number of years. They have no idea there's mold in their walls because it never came to light. There's no one had to knock a wall, no one had to do anything, and they may not know. So if they didn't know about it, maybe it's not so obvious, but there is no duty to disclose because they didn't have knowledge about it. Okay. Now, if someone is aware that there's a mold problem and it's potentially dangerous or unfit for habitation, they have to disclose that. There is an obligation to disclose that. From an agent's point of view, again, you have to comply with RICO. It goes back to what your duties of being honest and you can't be untruthful, and you have to go back to those principles to determine whether or not you have to disclose things and do it on instructions. And again, you're only obligated to disclose if you're aware of things. You can't, the law doesn't impose an obligation on you to disclose of things that you had no idea about. But once you do have knowledge, then you've got to comply with your RICO obligations and be careful with that. And again, from my point of view as a seller solicitor, no obligation to disclose a latent defect except if I had specific instructions from the seller to do that. Now, what are the buyer's rights when they've discovered latent defects? So the common law, okay, common law is just the cases that come out and they're decided by judges. That's what common law is. So what do the cases say? If a seller takes steps to make an inspection impossible, okay, whether it's multi-offers or not, or misrepresents the condition of the property, it's likely that the buyer would have a claim against the seller because the seller's taken active steps to prevent the buyer from discovering things on their own. However, if the buyer became aware of a latent defect or a patent defect for that matter before closing and decided to close anyways, the buyer will lose that ability to pursue a claim in court because they knew about it before closing. They basically accepted the property the way it is. So if they weren't happy with that defect, they have to raise that issue before closing. Okay, so if you discover something.
Can I ask a question here? Can I just jump in really quick?
Sure.
Does that give the buyer the right to terminate the contract? Without penalty?
Possibly. Like it depends on the nature of the defect, but it might. Okay, because that's the time to raise it. If they're aware of it before closing, that's the whole reason you have an inspection clause, and then you have the results of the inspection. The inspection says, you may have, if your clause says you have the right to walk away. If you find something that you're not happy with, then you can walk away. Oftentimes that decision might be made. Sometimes the buyer says, well, I'd rather try and do an amendment with the seller and let's see if I can get the seller to fix it before closing or fix it at their expense, then maybe I close that way. Okay.
I'm just wondering, like say in a multiple offer situation where your condition of inspection was not permitted.
Right.
You're the winning bidder, and then you discover later before you've moved in that there are issues. Are you stuck?
Yeah, you're stuck. And that's the danger of not having inspection clause.
Buyer beware.
So,
okay.
Right. So even if you don't have an inspection clause, you still want to get in and do an inspection, but it's not with a home inspector necessarily, but it's going to be an inspection to at least see the patent defects. You want to at least discover those. Okay. Now, again, if a patent defect is something that if you did walk through the property, you say, oh, I like this, I like that. I don't have inspection, but I know I got to, it's a bit of a fixer upper because you see certain issues that you have to do. But once you accept the property that without an inspection, you have to close and take the property as is, okay? If you become aware of a latent defect, which is different, before closing, and you decide not to raise the issue, then again, you're stuck with it as a buyer. You're going to lose your right to raise it after closing because you knew about it before closing. Okay, if it was a latent defect that you didn't know about before closing and it comes up after closing, that's different. Okay, so a seller has a duty to disclose the latent defects. Failure to disclose that is a misrepresentation. Buyer could have a claim against the seller. Okay, but not all latent defects are created equally. So that liability really only arises if the latent defect renders the property uninhabitable or dangerous, and the seller had knowledge of that. So for sure, there's going to be a claim that the seller is going to be responsible for in those situations. Okay. And this leads to the importance of your drafting an agreement of purchase and sale. Because if it's not a latent defect that fits into that core category that makes the property uninhabitable or dangerous, then we have to look to the representations and the warranties in the agreement of purchase and sale, including the entire agreement clause that's in the standard TREB form, standard AREA form, okay, referred as the entire agreement clause. And it says that this agreement, including any schedules attached hereto, shall constitute the entire agreement between the buyer and seller. And there is no representation, warranty, collateral agreement, or condition which affects this agreement other than as expressed herein. So what that means is, if you don't put specific warranties and representations in your agreement of purchase and sale, then there isn't anything. It doesn't matter what the conversation was. It doesn't matter what the multiple listing offers said, what the MLS listing said about certain things. Those aren't binding on anybody unless you attach that MLS listing as a schedule to your agreement of purchase and sale, okay? Unless, if it's not in your agreement of purchase and sale, it's not binding on a seller. So if you want the seller to make a representation and a warranty about something, you've got to put a specific clause in there. If you want them to represent and warrant that the property's never been used as a grow op, you've got to put that clause in. If you want there to be a representation and warranty, you want to know that there's never been a flood or a fire in the place, you would have to put an express clause in there where the seller represents and warrants that. If it's not in there, in a schedule, then this entire agreement clause that's in the standard printed form will defeat any other claims that they might have afterwards. So here's a little example of a case law. A buyer found a leak in the furnace room and the basement walls were ripped apart. Water was entering from a hole in the foundation that wasn't visible until the drywall was removed. So they claim that the seller was liable for the buyer's damages because the seller didn't disclose this latent defect. You know, it wasn't apparent until they opened up the wall. So it wasn't a patent defect they could have discovered. It's a latent defect. It was in behind the walls. So it was not discoverable on a reasonable inspection. So it falls into the latent defect category. And there was no warranty or representation in the agreement purchase and sale. So what the court decided here, the seller had no legal duty to disclose because the defect didn't render the premises uninhabitable or inherently dangerous. So it wasn't a big enough problem to render it uninhabitable or inherently dangerous. So this was some water. Now, you could have had a very similar set of facts and maybe the water had been going on for a long time and now there's mold all over the place. So this defect then it would have rendered the premises uninhabitable or inherently dangerous and the decision would have been different. So any of these things, we have to look at the facts. Whenever you're dealing with common law or cases, we always have to look at the facts. So this might be a little surprising that that was the decision, but it just, the latent defect didn't rise to meet that last test of making the place uninhabitable or dangerous. Now, you can make a claim for negligent misrepresentation against a seller, but you've got to go through these tests to see if they're all met. Okay, if you're going to claim that the seller was negligent and made a negligent misrepresentation. So there has to be a duty of care between the parties based on the special relationship. It's between a seller and a buyer. So that's pretty straightforward. That's a sort of an easy test to meet. The representation must be untrue, inaccurate, or misleading. So this is, again, when you do have a misrepresentation in writing in the agreement, was it untrue, inaccurate, or misleading? Like, when the seller says something and I rep and warrant something knowing that it's not true or it's misleading. And the seller must have acted negligently in making that representation. And number 4 is really important. The buyer must have relied on that negligent misrepresentation in making its decision to go ahead with the transaction. So the reliance by the buyer has to be detrimental to the buyer, and as a result, there's damages that resulted because the buyer was totally relying on the seller to tell them about this situation, and then the seller was untruthful, made a negligent misrepresentation the buyer was relying on. So the buyer was closing deals because they were relying on what the seller was telling them. So then there could be a claim for misrepresentation. There's a statute of limitations that comes into play in here, that you've got the buyer has 2 years from the day that they discover the latent defect to start their action against the seller. If they miss that time period, they're out of luck for bringing it. And that 2-year period starts when the buyer first discovers that latent defect, or on the day when a reasonable person should have been able to discover it. So that's when the 2 days starts to run. And they lose any recourse to take action on these things once we get to the 15th anniversary, on the day that the seller should have disclosed the latent defect to the buyer, regardless of when they discovered it. So it's not like, that 15 years is a long time. We're not going to, that I'm just putting that there because that's what the law looks at, but it's not something that comes into play very often. Now, I really want to get into this part of it because this people find very interesting in general. What is a stigmatized property? Okay, so we've talked about patent defects that are visible to people. We've talked about latent defects that are sometimes buried. You need a more qualified inspection. You got to do a little digging to figure out that. What's a stigmatized property? So a stigmatized property is non-physical, intangible attribute of a property that may elicit a psychological or emotional response from a potential buyer. Okay, it's not the buyer looking and saying, "Oh, there was a flood and I'm worried about mold." It's not that. Okay, that's a physical thing that they're looking at. They can see a damage to a wall. They can see stains. It's not that. This is non-physical that has an effect on somebody psychologically or emotionally. It disturbs them. It's a subjective test to the buyer. It's not what would the overall general population think if they had this information. Would it bother them? Would it create an emotional response from them? It's no, the test is how does this affect a particular buyer? And so when you're looking at a subjective test, there's a whole bunch of factors that come into play. Their culture, their own values, their gender, their individual history, their ethnic background, their age, their unique sensitivities. Some people are obviously more sensitive things to their perception, different things, different beliefs, religious beliefs, things like that. These are all relevant factors when that goes into someone just being upset about something that could be affecting the house that they're potentially going to be living in. And there is no database that keeps track of stigmatized property. There's no police or municipal database that says that certain things happened. So what are examples of stigmatized properties? Something that was previously owned by a notorious individual, like an organized crime leader or someone that committed a murder. It doesn't mean the murder or a crime was necessarily committed in that house, but just the fact that the house may have been owned by somebody who may have been notorious can make that house a stigmatized property. And again, it's in the eye of the beholder. It may not be stigmatized to everybody, but to some people, it might be a stigmatized property. If the property was used in the commission of a crime, it was a chop shop, a drug dealing place, a brothel, something like that, if that was going on, that would become a stigmatized property to some people. If there was a death at the property, whether it was a natural death or even an illness in the property, whether it was a murder or a suicide, depending on who's looking at this, that become a stigmatized property. And then the one that Don likes to raise is, are there ghosts? Is the place haunted or perceived to be haunted for some reason? Was it a former grow up that's been remediated? And again, you have to look at these things from every individual's point of view, because what might be stigmatized to one person is not necessarily stigmatized to another person. So let's go through the duty to disclose a stigmatized property. From a seller's point of view, this might be surprising, there is no requirement to disclose. And the reason is the facts may constitute a stigma to one buyer, not to another buyer. So we don't have to disclose it because it might be immaterial to a whole bunch of people, but to certain people that might be very material. And it could be just something as simple as, there was a natural death on the property. To someone that might be very upsetting or disturbing. And to a lot of other people, like they know that people get sick and people die, and it makes no difference on their decision whether to buy a property or not. So the general law is that a seller doesn't have to disclose a stigma. There is no legislation or case law in Ontario that requires a seller to disclose the existence of a stigma to potential buyer. It's really clear. There's no obligation on the seller. Okay, they don't have to proactively disclose the history of the property, even if it carries a stigma. It doesn't matter. Like, there's no duty. Someone could have owned a property for 20 years, but maybe the people before them was a crime lord or something like that. They certainly do not have to disclose it. It doesn't matter. Okay, no duty to disclose to a seller. Now, it's different from your point of view as an agent. Again, there's no legislation or case law in Ontario that requires you as an agent to disclose the existence of a stigma to potential buyers. However, and this is a big however, and this is where agents get this wrong sometimes, you have to comply with your RICO duties, okay? And your RICO regulations and rules about being truthful and honest, etc. So this is the game changer for you as an agent, because once you have knowledge of these issues that are considered stigmas, you have to comply with your RICO obligations. So even though your seller has no duty to disclose it, you have an obligation to comply and answer questions truthfully. So we got to go back to what RICO tells you to do. You have to avoid misrepresentation or error when promoting the property. You're forbidden to be untruthful. So if you're asked a question, you got to decide what to do. So if you're asked a direct question about it, you're either going to answer truthfully with the consent of the seller, or you decline to answer and suggest that the buyer and the buyer's agent conduct their own independent research. So again, you got to go back to what your instructions are going to be from the seller. If you don't agree with what the seller wants to do, you either have to comply with the seller's wishes or you have to decline to work with that seller.
David, we have a question here, if I could just jump in for a second. Is there a way to check the records of the seller? So I guess what this question is asking is, how do we find out if the seller is a notorious person? Is there a way that we can check that? No. And if so, no.
There's no general data bank. People sort of discover this because they know if someone's notorious or famous enough about, they might know about it, but there's no data bank that just keeps track of these things.
Right. Next question.
And again, the reason is it's not material to a lot of buyers out there. There's a lot of buyers that just won't care about any of these things. Like, someone will generally buy, no matter what's happened in a house, no matter what the stigma is, there's almost always a buyer for it.
Yep.
Okay. And the
house. So I had another question on this too. So the term disclose, that to me indicates that if I ask you that you don't have to tell me anything. You don't have to open up and tell me that information. But if I ask you, the seller or the seller's agent, a direct question, you only have to disclose if the seller has given you permission to?
You can only disclose if they've given permission for you to do that. Okay, you have to answer truthfully. You can't answer falsely, right? But if you're going to answer truthfully, you've got to have instructions from the seller, or you have the right to say, I can't answer that question. I'm not going to answer that question. You have to do your own research on it. Now,
Sure. I think a lot of our Markham agents will know
you're
that
raising a red flag to a buyer's agent to poke around. Okay.
Yeah, a lot of our Markham agents would know, like there's a property on Larkin Avenue in Markham that was the scene of a double homicide a few years ago. That property has been sold a few times, but it's always had like notes in it that, you know, there's something we need to talk to you about. So they're obvious disclosing the information up front.
Right.
There's also been on my in-laws' old street, ironically enough, 2 houses, one where there was a murder victim found, but they weren't killed there. It was a real estate agent actually. And another one across the street where there was a fire and another, I think it was some kind of family murder suicide situation. So like, because it does seem to happen a lot. So it's just, I guess you rely on Google, you rely on your knowledge of the local news, you know, things like that.
Right. Yeah. Let me give you an example that I had a few years back. Acting for the seller of a house, and this lady's husband died by suicide in the garage. Okay, and we're acting for the seller, and there's an agreement of purchase and sale. Like there wasn't any disclosure. Agreement is signed, and we're moving towards the closing. And they show up for one of their not an inspection, but just a visit type of thing, and they're hanging around outside the property, and a neighbor comes by. And you talk to, you're the people.
Always the neighbors will get you. It's always the neighbors.
You know, you need anything, you know. And isn't it too bad what happened to Mr. So-and-so in the house? You know, he was such a nice man, and they're going like, what? What happened to Mr. So-and-so? Oh yeah, you know, he committed suicide in the garage. So this, you know, was very upsetting, obviously, to the buyers, to the point that they refused to close the transaction, and the transaction didn't close. Now, what happened from the agent's point of view, the agent didn't know about this, as it turns out, but now did know about it. So now the agent would have to disclose this to the next, they want to go back on the market, the agent would have to disclose this to the next potential buyer because they now have knowledge. And it was not a great market at the time. We weren't in like today's market. It was a tougher market to sell properties. So the seller didn't want to use that agent anymore because the seller could say, I can go back on the market. Me as the seller, I don't have to disclose. David Korman's my lawyer. He knows all about this right now, but he can still act on the sale because he's got an obligation not to disclose it. And so he can still be my lawyer, but I can't work with this real estate agent anymore because the agent knows about it. So I'm going to go back on the market with a different agent that doesn't know about it. I'm not telling the agent about it. And hopefully my nosy neighbors don't come around. I'm going to try again. And that's what ended up happening. So the agent lost a transaction here. The property got resold through another agent who never was told, never knew about this. And they found another buyer that came and bought it, and it closed. So actually, you know, unfortunately she took a bit of a hit on it because it was a lousy market. Anyways, it's bad news to the agent because the agent had knowledge, and once the agent has knowledge, they've got to tread carefully with it. So sometimes not knowing is better than knowing because you've got to follow your RICO information.
Plausible deniability.
Exactly. Yeah. Now I'm going to tell you one story because I always like to tell this story. It's sort of a personal story, which sort of gives you a good example of stigmatized property. So my wife and I lived in the same house for, I guess, about 25 years. And about 8.5 years ago, you know, our kids are now gone. We're empty nesters, and we decided to move. And we weren't moving very far, same neighborhood, but we were just looking for a different type of property. So, you know, and I've been practicing real estate my whole life, but every once in a while, it's good for you to buy or sell a property because you get a different understanding of how the law works and how these things work on a personal level. So as it happens, my oldest son is a real estate agent. He's actually a fabulous real estate agent. And I guess at the time he had been out about 5 or 6 years. So he's acting for us. So he sets up an appointment with us to go see a house that met a lot of our criteria. And he takes us there like 6 o'clock at night. And the agent meets us at the door. They're the selling agent. And she says, you know, unfortunately, you know, the family is home. And they still didn't want to cancel. I'm sorry for springing this on you, but the family, you know, just they're dealing with this situation. They're going to stay in one bedroom upstairs. The grandmother, the elder, you know, the mother of the person that owned the property of the couple, the husband's mother was ill and she was upstairs and they couldn't get her out of the house. They're just going to stay in that one bedroom. Please come in. Don't cancel. Don't reschedule. You have to come in and see the house. A beautiful house, blah, blah, blah. So my son is very embarrassed that he's dragged his parents here and we're going to a house that's not vacant. And obviously this is way before COVID, etc. But still, you know, what do? We're here already. Let's go look at the house. Now, as it happens, my daughter had been away for 4 years university and she was just moved back to live with us, and she was going to move into whatever house we were going to move to because she was going to do a master's at U of T. So she was actually coming back to live with us. So she was going to be living. So she's with us for this visit as well. Anyways, we're looking through the house, beautiful house. It's meeting all our criteria, blah, blah, blah. We're interested. We go upstairs and there's one door that's closed, one bedroom door. And then they open it. Oh, you please come in. You have to look. It's a beautiful bedroom. We just did the drapes in here. It's a great room. No, it's okay. We don't want to see it. No, come in. Anyways, they insist we come in and we go in and the elderly lady's in a hospital bed in the room with machinery all over and tubes all over and breathing apparatus. And her son is kneeling at the side of the bed, like saying prayers. And they're trying to, you know, look at how nice the window treatment is in such a nice room and look at the carpet. And this lady's like on her deathbed, basically in there. So we were trying polite. We couldn't get out of their, you know, out of the room fast enough. And then we walked down the hall. We're walking away, and my daughter, you know, who's like 22 at the time, you know, is behind me, and I turn around to her and I say, you know, Lindsay, you know, that's going to be your room. So she just lost it, you know, because we knew instantly, as soon as we saw that room, there was no chance that we're going to take that house because that became a stigmatized property to us. The reaction from my daughter, I saw in her face that she's going to go live in that room where she just has this image of this dying lady in there. It's just never going to happen. So obviously that didn't happen for us. That became a stigmatized property.
And that's crazy because if they hadn't insisted, you probably wouldn't even have gone into the room, right? Like, that's nuts.
Right. And I don't know if the lady ended up passing away there or not, or maybe she ended up going to a hospital and like, who knows? But eventually she died, but she was sick in that room, but we had that image in our head.
Yeah, you'll never be able to
get rid of that
picture out of your head. Exactly.
We'll never get rid of that. But someone else bought that house. Okay, maybe they saw the same thing we saw. Maybe they didn't. Maybe she was already gone. But someone will buy that house. Like a house will always sell. But again, it's just an example of how it's a subjective test. It's to us, how are you going to react to that? And before seeing that for myself, I never thought, okay, if I were to buy a house that someone was sick in, or someone may have died from natural causes or something, like I wouldn't care. You go in a house, you put fresh paint in, you decorate as you want, and you live there. Like people get sick all the time, and people die in their homes. But when you have that image, all of a sudden that became stigmatized to us. Okay. So
we have one more question here, actually, going back to your previous example, if you don't mind.
Yep.
With the nosy neighbor who blew the sale. Would the seller be able to sue the neighbor?
No. Okay. No. There's no contract between the seller and the neighbor. She, you know, she wouldn't know if it's truthful or untruthful. She wouldn't even necessarily know the real facts, or maybe she does, or she's got a big mouth, but she has no duty to anybody to not disclose.
Okay.
You know?
And one more question here.
I don't know if they had a talk with the neighbor and said, you know what, like, you know, keep your mouth shut and your business. And, you know.
Here's $1,000. Stay in your house and shut up.
Yeah.
One more question here about your second example. What if
Yeah.
you bought the house and the woman died between offer acceptance and closing and it was an issue for you?
That's a good question. I think they wouldn't give us a right to get out of the transaction because we now had seen that there was someone sick in the house. Okay, and we've decided to go ahead with it. So I think an argument we made that we've accepted whatever was going on there. We accepted she was going to get sick and get better, or she was going to die, or she was going to move to a hospital and die. But I think we saw what was going on there, so we had knowledge.
And if you hadn't seen her?
Yeah, no, and if we had never seen, if we never opened that door and and bought it sight unseen, and then found out afterwards that someone died in there, there was still no duty to disclose it to us by the seller.
Probably
So,
less of a liability or potential liability because you don't
yeah,
have that mental image in your head at that point either.
yeah, because if it was that important to us, we would have insisted on opening up the door to
Right.
see what's in there.
What was going on? Okay, question from a latecomer here. Does this no disclosure requirement by seller also apply to marijuana grow-ops?
Yes. Okay. Now, the thing with grow ops, and I'm going to get into that a little bit. We're going to talk about this, buyer beware and duties like that too. Like something can be a grow op and be totally remediated, and it's no longer a grow op. Okay. If it was all remediated properly, it's the same principle. You can have a leak in your basement, but if you fix the leak properly, proper people are doing it and you completely fix it, it's not something you'd have to disclose because it doesn't exist anymore and it's been fixed. There could be a fire that could have destroyed half the house, but if it was fixed properly and rebuilt and proper remediation was done, so the issue doesn't exist. There's nothing toxic about it. There's nothing in there. You don't have a duty to disclose that at one point in time, 10 or 15 years ago, there was a fire or there was a flood, or that something part of the house was used for a grow op, as long as it's been completely remediated. Okay. Now that's different than if it wasn't completely remediated and you're just sort of hiding the fact that it was used for that, because then you do have a duty to disclose because there could be mold in the property. And I'll get into that a little bit here with what we're going to talk about. So we're talking about the doctrine of buyer beware, because buyers are ultimately responsible to satisfy themselves that the property is suitable for their purposes. So that doctrine sort of shifts the burden to a buyer and make sure they do their due diligence. Okay, and that's the doctrine, unless there's something specific in the agreement of purchase and sale. That's why I made that point before about if you want there to be representations, warranties in the agreement, you got to make sure they're in there. It can't be a verbal representation warranty. If there's nothing in the agreement, then it's buyer beware is the guiding principle. So if you suspect something or aren't sure about something, you got to push to get a rep and warranty. These days, when you can't get an inspection done because of multi-offers, you want to try and get a rep and warranty in there at least. Sometimes you can't even get that in because of the multi-offers. But you have to know if you can't get anything in like that, then it's buyer beware, and the buyer's got to accept the property the way he sees it. Okay. Now here's the question on the grow up. I wasn't going to talk about it, but I just threw this in there. I just drafted this in the last 20 seconds because the question came up. So what's the issue with cannabis? So cannabis plants and the heat from the process, they create a great amount of humidity, which causes damage to the property and creates these mold issues. So that's the problem with cannabis, whether it's legally grown cannabis or illegally grown cannabis. It's the humidity and the potential mold that's created by it. And that's why it's an issue. It's not necessarily just the stigmatized thing that, it used to be, run by, by someone who was using it as a grow op. So it could be any crime. It happens to be cannabis. It could have been another money laundering thing. It could have been selling other drugs. It doesn't matter. But the issue with cannabis is an important issue because it actually creates damage to the house through the mold issue. So that's what we're looking for. It's the mold spores that make a place unfit to live if it has not been properly remediated. Okay, you need a proper company that comes and knows how to do this properly, get rid of all the mold spores. Okay, so that's the important question. And similar issues come up with other things, other operations like for fentanyl, other opioids. It's what remains in the property that become dangerous to make it unfit for someone to live in if it's not cleaned out properly. So back to cannabis for a second. These are plants. They're grown in small rooms generally that require a lot of light, regulated light, a lot of darkness, and a lot of heat. And sometimes mold can be visible, sometimes it's not visible. And there is a police database of grow-up operations. But that's grow-up operations where the house has really been conducted as a business as a grow-up. That's different from a lot of homes that just have some marijuana plants that have been grown for personal consumption or small community, but not necessarily considered a grow-up. So that would not become part of a police database. Now, what's the duty to disclose if there's a grow-up? So from a seller's point of view, a seller must disclose a grow-up when there's actual material latent defects. So, okay, wouldn't be seen, not a patent defect, a latent defect. It's something that's going to be in the walls, okay? If the buyer asks a specific question or expresses a specific concern, they would have to disclose that. If the agreement of purchase and sale has a representation that the property was not used as a grow-up or for criminal activity. So that's why we want to put those types of clauses in your schedules, and most of you are doing that. You have that standard clause that Century 21 Leading Age gives you, that the seller is making a representation or warranty the property was not used as a grow-up, okay? So that is a means of disclosure if the seller is making that statement. If your seller refuses to put that type of clause in, ding, 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 like the bells go off. Why are they reluctant to put that in? Okay, so you're going to be asking those questions. And from your point of view as an agent, again, no case law requiring you to disclose the existence of a grow-up to potential buyers, but unfortunately for you, you have to comply with RICO again. You have to answer truthfully. You have to get the seller's consent. You could decline to answer. You got to go back to that. You have to comply with the seller's wishes. You can't misrepresent things. So when you do have knowledge, you have to answer truthfully or decline to answer. And again, every time you got to make sure you're doing it with the instructions from your seller client. And again, it's easy from my point of view as a lawyer, no obligation to disclose. My duty is to the seller, a duty of confidentiality, unless the seller specifically gives me instructions to do something. So this is like a typical grow-up clause that you've been using in your agreement of purchase and sale. The seller's representing that during the time the sellers own the property, it's not talking about prior ownership prior to the seller, but during the time the sellers own the property, they haven't used the property for the growth or manufacture of any illegal substances, okay? And to the best of the seller's knowledge and belief, the use of the property and the buildings and structures have never been used for the growth or manufacture of illegal substances. So the second part is talking about prior ownership, but it's only if it's within their knowledge. They have no obligation to be digging and checking the history of all the prior owners. They're just saying, to the best of their knowledge and belief, because they don't know anything. But they're saying is to their knowledge, it has not been used for the growth or manufacture of illegal substances. And while they owned it, they didn't use it for that. Okay, and that warranty would usually want to put in that it survives and not merge on completion, which means if the issues come up after closing, someone can still sue based on this warranty. Because if you don't say that the warranty will not merge on completion, then the warranty does not survive the closing and it merges on the closing, which means that a buyer can only rely on this clause if they discover something prior to closing. But once they close, they have no recourse to go back against the seller. So it's important you put that last part in your clause that it will survive and not merge on completion of the transaction in case something shows up after closing. Now, cannabis is now legal, okay? That changed in 2018. So now people are allowed to grow a limited amount of cannabis in their own place. Okay, so whether people are doing it for their own consumption and they're doing it legally, it still creates these issues of potential mold. So now if your clause just says that there's been no illegal growth of cannabis, that covers a grow-op situation, but that's not saying that the seller didn't grow their own for their own personal use as legal, for their legal growth of cannabis, and that could create an issue as well. Okay, so we have to, since it became legal, we have to look at these clauses a little bit differently. Okay, because that clause doesn't cover the if the buyer is buying and it turns out that the seller was cultivating their own legally allowed 4 cannabis plants in the residence. Okay, and then it's a question of how did they do that? What kind of heat and humidity did they create? And and did they know what they're doing? They were living in it themselves, but were they creating mold or something toxic in the walls for doing that? So we've got to change the clause a little bit to say that they're representing in warranty that during the time they've owned it, that they have not used it for the growth or manufacture of any cannabis. Okay, because as a buyer, you want to know whether the seller was growing their 4 plants or not. Okay, so if they're prepared to say that it wasn't used for any cannabis, then that includes them doing their legal 4 cannabis plants, and we know that the issue isn't there. Now, if they're reluctant to put that in, then again, ding, 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 the bells go off because maybe it wasn't used as a grow-op, but maybe they've been growing their plants, and who knows what they've been doing and how good a job they've been doing that. So that's why I want you to consider putting that and see if you'll put that type of clause that it's never been used for any cannabis, because they can now legally grow it. So,
sorry, David, what if 4 plants were grown outside in the backyard?
Well, that's different. That's if it's grown in the backyard, that's not creating damage to make the house uninhabitable. Okay, so that's not creating any lingering problem with the house. Those, if the plants are being grown outside, they can be dug up and they're thrown out if you don't want them, and that's the end of it. But it doesn't do any damage to the house. Okay, so we're really more concerned about growing the 4 plants inside. And again, this could be in a condo, okay, as well as in a house. And it depends, how they grew it. So again, duty to disclose from a seller, no obligation for a seller to disclose that the 4 plants were legally grown in the property, unless they created damage to the property enough that would require remediation or becomes a latent defect. Okay, if they did a good job and they grew these 4 plants and there was a very controlled environment in a tank or something like that, and with no chance of any spores going into the walls, or they have no duty to disclose that. Okay, if the way they were growing it created damage that would require remediation or potentially be a latent defect, then the seller's obligation to disclose changes. From your point of view as an agent, you again do not have to disclose that these 4 plants were legally grown unless they created damage, same thing, to require remediation or latent defect known to you. Okay, and again, you always have to keep in mind your obligations to comply with RICO, act honestly and truthfully, etc. So you got to go back and look at those principles each time. And from my point of view, like we're the easy ones in all this. From a lawyer's point of view, no obligation to disclose unless we get specific instructions from a seller. So a buyer's agent wants to put in a clause, a legal cannabis clause in the agreement of purchase and sale. You should want to try and put that in, because that's going to flush out the issue. I want to put a clause in that not only has there been no illegal growth, not only to grow up, but it's never been used for the growth of any cannabis, even legal cannabis. You want to put that in there, because now you're going to see what the reaction is going to be from the seller, because the seller is going to say, no, I can't sign that because I can sign something there's not been a grow-op. I can sign something there's been no illegal manufacture or growth there, but I can't say there's been no legal growth of cannabis if I, in fact, have been growing cannabis. So now I have to disclose that. And then it's up to the buyer to decide whether or not that's good for them. And then they got to look further to see, okay, how was it grown? Is there a potential for there to be a health issue here? So that's sort of the process that you have to go through. So it's always a good idea from a buyer's agent to try and put that legal cannabis clause in there and see what kind of response you get from there. Okay.
Do we have a copy of the legal cannabis clause?
That's the one that I'm just going back to here on the bottom of this slide, that it's not been used for the growth and manufacture of any cannabis. Okay, because if you say any cannabis, that'll cover whether it's legally grown or illegally grown. There hasn't been any cannabis there. Okay, so you can just do it simply like that, or you can tailor the other one, the previous clause, to say, have all the language, there's no illegal manufacture or growth, etc., and then go further and say, and there's never been any legal cannabis growth. Just got to add in the fact that there's been no legal cannabis growth as well, because to a lot of buyers, that's an important thing to determine. So I know we're running short on time. I just want to touch on Kitech plumbing a little bit too, because this is an issue that comes up on this. So Kitech plumbing is a type of plumbing that was used, not being used anymore. Earlier in the 1990s and in 2007, there's a big recall 2005. Anyways, it's a type of plumbing that's defective, and the fittings were defective, and it degrades, and it creates blockages, it creates pipe bursts. And unfortunately, this was put in a lot of just residential homes. It was put in a lot of condominiums too, and it's uninsurable and it has to be removed. You can't fix it, you have to replace it, and it's an expensive process. So what's the duty to disclose if there's Kitech plumbing? So a seller's duty depends on whether it's a patent defect or a latent defect. Sometimes it's obvious, you can see that the plumbing, because it's exposed in a property, and you can see, anybody that would look at it can look at the plumbing and see that it's Kitech plumbing. If it's buried in the walls, it's different. Okay, so there's a different duty. From an agent's point of view, again, it's your obligation to RICO. It depends on what your knowledge is, and you have to answer truthfully. From my point of view, I don't have to disclose it unless on instructions. Seller property information statement. Okay, this discloses information to a potential buyer. The seller isn't warranting the information, it's providing certain information. And it's primarily information not readily visible that would affect a reasonable person's decision to buy the property. If the information changes prior to closing, the seller has to update the information. So if you've provided one of these information statements and then it changes, you have to update it and provide new information. But it's not a compulsory part of a purchase and sale agreement in Ontario. A seller is under no obligation to complete this form. And you have to be careful with it, because liability could extend to you as an agent. So you have to decide whether you're going to use it or you're not going to use it. A buyer can't really rely on this unless you're going to attach it as a schedule to the agreement of purchase and sale. Okay, unless sellers are being untruthful or seller's agent are doing things, you've got to look at your duties, and you've got to be careful if you're using these statements. Okay, but you have to know it's not a compulsory part. And if you're on the buyer's side and you see information in this that you're really concerned about, you should try and get that attached as a schedule to the agreement of purchase and sale, and create it into a form of representation and warranty by the seller if you want to be able to rely on it. So I just put a couple examples of a case line here that I'll just run through quickly. Here, the seller and the seller's agent were aware that the property had plumbing issues that went back 17 years. Seller didn't disclose it in their statement, and the seller's agent had knowledge of it, failed to make the buyer aware of the defects prior to the sale. So this goes to court, and the decision was that the seller's agent lack of diligence in reconciling misleading statements made the statement, the fact that they issued the statement amounted to negligence. And in this particular case, the judge found that 50% of the fault belonged to the seller for not disclosing, and 50% belonged to the seller's agent for failing to warn the seller and going through the ramifications of putting false statements and failing to bring the issue to the attention of the buyer. So they were found responsible for damages to the buyer, and the judge gave a 50-50 split, partly on the seller, partly on the agent. So just be careful with these things. So just last thing I want to really go through some of the best practices for sellers, agents to go through. Sorry. This is for sellers, agents. Take all reasonable steps to determine and disclose all facts about the property that might affect someone's decision to buy. Okay. Don't just accept the seller's verbal representations, but be very careful to avoid misrepresentations, error, or concealment of facts. Remember what RICO is telling you to do. Agents have an obligation to act fairly, honestly, and with integrity. And if in doubt, always err on the side of disclosure. Okay, failing to disclose a material fact may have consequences both in civil liability, like that previous case example where the agent was liable, and with your standing with RICO. So you got to be careful. So you should be erring on the side of disclosure, but you also have to be careful how you disclose. Make sure you're getting instructions from your seller. Your seller's relying on you as an agent. You know more than they do. You've attended this webinar and they haven't. Okay, you have the duty on you. You're the one that's advising them. You're not sure, you know, get in touch with me as well. Get in touch with a lawyer and run the situation past facts. Situations are always different. Okay, but you've got to be careful. Ensure that you're providing accurate information to a buyer. You're not misleading to a buyer. Now, if you're on the buyer's side, here's some tips, best practices for a buyer's agent. Okay. Buyers ultimately have the duty to conduct their own investigation. Very difficult right now in this kind of market when they can't do full inspections of properties and they're taking risks, but they have to, your role as an agent, you've got to explain to them that they are taking certain risks, and it's partly driven by the current market conditions because we can't do full inspections, etc. Okay, so you also have to know your client on issues that are important to the buyer. You've got to make inquiries with the seller or the seller's agent. Okay, so certain things are important to some buyers, certain things are not important, but you've got to understand your client, what they want to do with the property, who's going to be living there, and what's important to them, and you might want to make further inquiries. So you have to have these conversations with your buyer. Okay, you've got to understand them. Unfortunately for me as a lawyer's point of view, we don't get that opportunity. It's a great way to get to know your clients, but you want to understand what they really want with the property, what their family situation is, who's going to be living there, who's going to be in what rooms. You know, in my example, I could have gone to this house with just me and my wife. My daughter may not have been there. And maybe that bedroom was just going to be my office and I was fine with it. That's a totally different fact scenario than, no, I needed that bedroom for my 22-year-old daughter to move into. So that changes my whole outlook on the use of that house. It's important for you as an agent that you ask these questions. Okay, do any investigations you can possibly do, make these inquiries, and try and get a representation and warranty in there, okay, to the best that you can, again, given market conditions and whether or not it will be acceptable. But even the attempt to get some of these in, it elicits a response. So you want to get a representation. If you can't do a full inspection, especially an intrusive inspection, you want to have a rep and warranty that there's no asbestos, there's been no leaks or mold, things like that. Especially when you're in a situation where it's not conditional on an inspection, you want to try and get a rep and warranty in. If they refuse to give you a rep and warranty, that's where the bells go off. It gives you rise to concern. And because now your buyer client might be assuming certain risks that they may not want, and you don't want to put them in that situation. And maybe this property is not for you, maybe for them. Maybe you just have to go down the road and find them something else, okay? Because a seller's refusing to give you information and you don't want your client to take that risk. So I'm going to leave it there. I'm sure there's some questions, and if there's some you can answer, I hope they'll answer today, and you can always reach out to me at any time. I'm always available, and we'll try and get back to you. So reach out by email or a call, and I'll try and answer questions the best I can. But Dawn, I'm assuming you got a couple things there.
Yeah. If you attach the MLS listing to an agreement of purchase and sale, and there's representations in the, are the representations in the listing binding?
Yes, if they're attached to as a schedule to the agreement of purchase and sale, then their representations are in there. We had one the other day where a family was, there was in the listing, it said that there was hardwood floors on parts of the second floor, the upstairs floor or something like that. It turns out that they were laminated flooring, not hardwood flooring. So it's not, there was no representation in our agreement of purchase and sale that said they were hardwood. It did say hardwood flooring in the listing. The listing's not attached to schedule. The listing's not binding. It's not part of our contract. Buyer goes into the house, looks at it. You know, he can figure out for themselves, or should be able to reasonably figure out themselves, that it's laminated flooring. It's not hardwood flooring. So between the buyer, anybody that went with the buyer, the buyer's agent, someone could have figured. No one was hiding it. It was there for you to see. You sign an agreement of purchase and sale. There's no representation and warranty in the agreement of purchase and sale. The fact that it stated hardwood flooring in the listing isn't part of the contract. Buyer had a chance to see the property and bought what they saw. They maybe even liked it. Oh, look at this nice flooring here. They didn't investigate just to make sure that, you know, it's one material or another material.
Do you recommend that the agents attach the listing as a schedule?
If there's things like that in there that could be reps and warranties, then that's great. If you can get it attached, you know, in this market, it's hard to do that. If a seller is refusing to attach it, that should ring the bell and say, you know, why? What's in here that they're uncomfortable with? You know, what is there something in here that's misleading, right? If a listing said there's no high-tech plumbing, for example, and you ask them to put that in there, and they say, well, why do you want that in there? Because that way the listing refers to the fact there's no high-tech plumbing. So if you attach it as a schedule, then we've got a rep and warranty that there's no high-tech plumbing. And if they say, no, we don't want to do that, you know, so the bells go off. And you say, okay, you don't want to attach the listing. Let's just put a rep and warranty directly in the agreement of purchase and sale where they're going to say there's no high-tech plumbing. And they say, no, I don't want to put that in either. Well, that's sort of telling you that there probably is high-tech plumbing, and you don't want to take that risk. Okay, so I'm just using high-tech as an example. It could be for any of these things. Okay, so if you see something, the important thing is if you see something in a listing, then you as a buyer's agent should be questioning that, and you should be trying to convert that into some sort of rep and warranty in your agreement of purchase and sale. And remember, you don't want to just accept a verbal explanation for it, because if it turns out that explanation was wrong, whether they're intentionally wrong or unintentionally wrong, the buyer has no recourse, because there wasn't something in writing in the agreement of purchase and sale where the seller was providing a rep and warranty. So you have to try and get it in there. And then when you ask for it, if they're refusing to do it, that gives you reason to pause and decide whether or not there's something more here, and whether or not you've got to take a pass on this property, or you explain it to your buyer client and say, like, there might be these issues here. The seller's not telling us. So if you go ahead with this, you're taking the risk. Okay?
What about listing agents when there's multiple offers crossing off warranty and only allowing represents? Should that be like a major red flag?
Yeah, you know, then they're getting into semantics. So they're saying they're providing a representation, but they're not providing a warranty, or if they're providing a warranty and not providing a representation, you know, you really need both. And anybody that's reluctant to provide both, like, there's a reason for that. So you got to push a little bit. Like, why? Why won't you, you know, why won't you provide that warranty that it's not? And you might say, well, I don't really know. Well, if you don't really know, then how about putting into the best of your knowledge and belief? Like, we're not asking you to go and do anything or look at everything, but we at least want to know that you're not aware of anything, and that you put that in writing, that you're not aware of anything. Okay? Because if you are aware of something, then we want to know what it is before we buy this.
Apparently it said that their lawyer advised them to do it that way.
Yeah, well, lawyers can be very tricky and try and split hairs with it. And, you know, the lawyer may not want them to provide a warranty because they may not have that information. But again, the question goes to why. You know, what's the issue with it? Do you know something? If you know something, tell us what you know. If you don't know something, then put in that I don't know whether to the best of my knowledge. I have not conducted an investigation, but during the time that I own this property, the issue has never come up. I don't know anything. I've never had to deal with the issue. I don't know of anything. So all I can tell you is what I know or what I don't know. But I can get it from a lawyer's point of view. I don't want them to provide a blanket warranty that the property has never been used for any cannabis growth if I don't know that that's true. I've lived in the house for 2 years. I don't know if the people that lived there before me used it to grow their illegal cannabis plants, or the people before them grew 4 cannabis plants. So how can I provide a warranty that it's never been used? I can say, to the best of my knowledge, I'm not aware that it's ever been used, but I never asked the previous owners. I never asked the people that owned it before the people that I bought it from, but the issue never came up. So I can make that statement that to my knowledge, I don't know about it. I'm not aware of anything. That doesn't mean it never happened. It just means I don't know about it.
Is there any advantage to a seller or seller's agent to fill out the SPIS? Don't know why any seller or their agent would want to fill it out.
Yeah, I don't know if any of you are doing that. I don't know if you guys are recommending they be doing it. I don't, on properties where there's absolutely nothing to hide and it's very basic, very straightforward, I don't see any harm in providing information in there. But you've got to be very careful as to what you're putting in there. And, because that leads to further questions. And when there's no obligation to have that, then, in current market conditions, why do it? You're putting up a sign out front and you got 10 offers coming in. So, why do you want to put that risk? Let the buyers come in, take a look, and they're going to buy what they see. That's always better from a seller's point of view. You come in, look around, check it out, whatever you want, and then put your offer in, and you're going to buy whatever you see in its current condition. You don't like something, you want it fixed up, fix it up after closing. Okay. And that's the current market that we're in, right? We're not in a market right now where people are making offers and then conditional inspection, then they're coming back after inspection, and then, oh, here's a list of 10 things we want the seller to fix before closing. That's not the current market. We'll get back to that market. We got to look at it differently again. I'm sure we'll get back to a market like that where we're going to have to pay more attention to it. But from a seller's point of view, it better, no, come take a look. You like it, put an offer in. I'm not providing any reps and warranties. But if you have a suspicion as a buyer's agent that something happened there, then you should be questioning it. And then the way they respond to it will determine whether or not you want to go ahead and push the issue further.
Do we have to disclose aluminum wiring?
Again, that would be like the same type of analysis for the Kitech plumbing. If it's apparent, if you know there's something inherently dangerous, okay, then you've got to go through that, that test. Again, it depends on whether it's hidden or whether it would be apparent. Like if it's apparent for anybody that goes into the furnace room and looks at the electrical panels and all the wiring, because there's open ceiling, and anybody that's going in there would see what it is, then you don't have a duty to disclose it because it should be apparent to anybody. It's like, it's really, your analysis should be just like Kitech. If it's all buried, that creates a different issue. Okay. If you have knowledge and it's buried and there's nobody that can see it, then your onus is higher to disclose that.
If a home is in bad condition, like a total fixer-upper, and the agent says right on the listing that the seller and the seller's agent does not make any representations and warranties, and that the home is being sold as is, where is condition, is that good enough to save the listing agent from any future liability?
Yes. Generally, yes. As long as, assuming the agent isn't doing anything to hide anything or anything like that. But in that scenario, in that fact scenario, the answer should be a clear yes for the agent, because they're making it clear in their listing, promotional materials, anything they're doing, that we're not making any reps and warranties. it's a fixer-upper. There's all kinds of things, and you buy it the way it is, as is, whereas, come and take a look, and we're not going to fix anything. You like it, put an offer in. It's obviously going to be priced accordingly because anybody coming in is going to have a budget to fix certain things up. And again, on these things, you have to look at things from a subjective point of view, and that's where the law would come in. Someone would come in and, you know, I had a situation years ago. We had a client that put an offer in a house, conditional on inspection. When they did this, and there'd been a renovation, but it was the owner did the renovation themselves. Okay. So we couldn't get, you know, certificates from the plumber and the licensed electrician, you know, confirming that everything was done properly and there's guarantees and warranties. You know, the guy did a renovation himself. So he had an inspector come in. Inspector found a bunch of things that were wrong with it. Not things that couldn't be fixed, but it was a fairly extensive things that were wrong with it. And our buyer wanted out of the transaction. And it was simply that our buyer put every nickel together to meet the purchase price and had no budget or ability to have a budget to fix anything after closing if things showed up that weren't good. Or if the seller fixed it and it still wasn't good enough and things broke down because the seller was going to do it himself. And they had no budget for that. Plus they had no stomach for it to go through a process of, okay, we're going to close, but even after closing, the seller is going to come in and they're going to still repair things and fix things. And there'll be other trades coming in. The buyer didn't want to get into that. So in this particular case, the seller took offense and refused to provide a mutual release, refused to give them back their deposit money, and said, no, I'm keeping your deposit money. You're not taking a reasonable position. We could fix all these issues. To other buyers, they would accept this and they would accept our undertaking to fix this. And you have a duty to close. I'm keeping your deposit monies. So now that was obviously upsetting to my clients who needed the deposit monies to go and buy the next property. So it ended up not going to litigation. It was on the threat of litigation. And I was writing like 4 or 5 page letters. They had a litigation counsel and we never got it to litigation counsel because we were able to convince them and show them case law that the test is really a subjective test. It's what my particular buyer had a stomach for. And they didn't have a stomach for living through this fixer-upper that's going to be fixed afterwards, or potential things that could go wrong, you know, after closing and have to sue the seller after closing to fix it. And there's enough case law that say you look at it from this particular buyer's point of view. It's not what a reasonable buyer would do or what other buyer, it's this particular buyer didn't have a stomach for it. I'm sure they were, you know, eventually they sold the property to somebody else who accepted all those warts in it and were able to go ahead. Anyways, luckily we were able to resolve it and get our clients' deposit monies back so they can buy another property. And we did it, you know, it was almost going to litigation. Litigation lawyers wanted a $10,000 retainer, you know, just to fight to get their, I don't remember what it was $60,000 or $80,000 deposit monies back. And litigation lawyer wanted a $10,000 retainer to go to court to start fighting it. So like, who's got that kind of money when you really want to do is buy a house? You don't want to buy a lawsuit, you want to buy a house, and they need their deposit monies back. So fortunately, we were able to show enough case law and make a compelling enough argument that, you know what, you know, move on, sell it to somebody else and give us back our deposit monies. And they finally relented.
Perfect. Does anybody else have any questions for Mr. David? No, thank you for all the answers and informative sessions.
Okay, well, my pleasure. And this series has been a pleasure. It's funny, like this one we end on, which was a topic we didn't even have originally. And it's an interesting topic. I think you're all going to be dealing with stuff in your travels as agents when you've got different defects, whether on the buyer side, seller side. You'll have this material to go back and refer to. And any other questions, please reach out. Okay, but thank you for having me. And look forward to, we're going to try and put together another one on landlord and tenant issues.
Perfect. Thank you so much for everything, David. Everyone's clapping that I can see.
Thanks so much, David. Appreciate it.
I'm clapping for you too. Thanks for attending and thanks for your great questions.